Welcome to this Art Scene online music business workshop. I'm your host, Jonathan Shaw, and we are proudly sponsored by the National Arts Council. In this sixth video, we will look at sound recordings, videos, and performers' rights. Let's start with looking at copyright in sound recordings. So, from the last video, you'll know that you can have copyright in musical works and literary works. So musical works are the music, the melody, the written composition that somebody has come up with. The literary works is the lyrics of the song or some sort of poetry that's set to music, whereas sound recordings are the capturing or the fixation of that music or that performance in some sort of playback that one can hear over speakers. So there are various different rights that one can have with their sound recording that they now owned and commissioned and paid for. So you have the right to have a record embodying that sound recording. So you need to think of the sound recording being something that's outside of any medium or vessel that recording would sit on. So you have the right to be able to include it on the internet, on a CD, in some way, on a hard drive, whatever the case might be. You have the right to include that particular sound recording on those formats. Then you have the right to exploit that reproduction. So any copies that are made, you have the right to make sure that they are sent out for hire by way of trade. You can do it directly or indirectly. You have the right to exploit that sound recording. You have the right to transmit that recording in a diffusion service. So for example, through an exchange service on the telephone or something along those lines. You have the right to broadcast that sound recording on radio and television. You also have, very importantly, the right to communicate the work to the public, and that includes the right to include it on the internet. This is very much linked to the Performers Protection Act. So while sound recordings sit within the Copyright Act in South Africa we have the Performers Protection Act, and the performers themselves have specific rights. Those rights include the right to broadcast or communicate an unfixed performance. So if a performer is simply going to a television station to perform on air, they have the right to have their performance broadcast in the first place. It also can't be recorded without the performer's permission. So there must be some agreement with the performer that that broadcast is going to be fixed in some way. So record companies often have agreements with performers to be able to fix or record their performances. And then finally, let's say that performance just happens to be recorded. The performer has the right to reproduce any unconsented fixed performance that they might have given. So what this means that if it so happens that the broadcast was recorded and later wants to be reproduced by the broadcaster or even the performer themselves, it is the performer that has the right to their broadcast being recorded and then fixed and being able to be then reproduced as a sound recording. Then of course, if the performer's rights are used in a sound recording, so their performance gets used in a sound recording, they are entitled to royalties, a share of the royalties with the sound recording owner, being the record company often, and they'll get a share, and the general understanding is that it's equal, 50-50. And then of course, the record company may own the video recordings that are made by the artist. So in legal sense, we talk about cinematograph films. And of course, those films have various rights themselves. The right of reproduction, for example, to make copies of that film. Public performance in a public place, for example. Broadcasting rights on radio and television. This should all sound familiar now at this stage because we've spoken about them in the previous video. Very similar rights to sound recordings, so this shouldn't be anything new. Then the right of adaptation in the cinematograph work. And then the right to control that adaptation when it's changed. All of these are terms that we've spoken about before. And then like sound recordings, the right to exploit any reproductions that are made of that music video. And then finally, how do you use all of these copyrights? So you have various rights once you have those rights in the different categories of copyrights. So you own those rights and you can then license them, and you license them in different ways. So the first thing you need to understand is that you have a limited time to use those rights. For the writers of musical works and literary works, it's actually your life plus 50 years after your death that you are able to license these works. Whereas for sound recordings and cinematograph works, commissioned works, you have 50 years from the first publication of that particular work. And there are other complications that are involved, but that's the basics of how long you own a work for. Then, of course, the assignment of copyright can be split into various different mechanisms. These include the transfer of the rights. So very often a music publisher will want you to transfer your rights to them, or a sound recording will include a record company, and as an artist you'll transfer your performance rights to the record company and they'll own those rights instead of you. Then, of course, there are non-exclusive rights, and these refer to rights which are granted to users and are often granted very often. So the same rights can be granted to many users. So you might have the right of public performance, which then you go and license to a lot of other performances. And those non-exclusive rights are often licensed by collective management organization. And then, of course, there are exclusive rights. So you might be the owner, but you give the exclusive rights to your sound recordings that you may own to another record company for a certain period of time, for example. And not even you will be able to exploit those rights. They lie with another party. And then finally, you'll issue licenses. And a license is either a long-form contractual agreement, or they some sort of invoice which just allows you to simply give a scope and a period of time and a method in which the license will be used. Great, I'll look forward to discussing more about the music industries with you in our next video.